You can just do our excellent. Thanks, Anita. Good. And hopefully you can all hear me okay as well. Good. Okay. So I'm going to minimize this. Hopefully we're good. Excellent. Okay, so my name is Claire Harrison. I'm the Managing Director of Harrison's. We're a HR consulting firm that was established back in 2009. Today, the webinar is around a very hot topic. It's the latest changes to the Fair Work Act. I'm going to talk specifically about the changes that have happened. Most of them have happened on Monday, actually. So I'll talk about those. There's a whole lot of changes I'll touch on. But look, the devil is in the detail with these things. So I'm going to present, but each organisation has a different requirement. You've got different positions, so it will be different, but let's give it a good go. I'm not taking questions throughout, only because we have so much to get through, but happy for you to contact me at some point later and I can answer those questions. So let's get going. Okay, a disclaimer, Harrisons are not lawyers, so we're not giving you any legal advice, nor is any of our advice specific to your situation. Like I've just said, the devil is in the detail. So each organisation, based on your award coverage, your enterprise agreements, will be nuanced. So a disclaimer around that. Just a little bit about Harrison's for those who don't know us. So Harrison's is a HR consulting company. Like I said, we were established in 2009. We have 4 service areas, being consulting. So consulting is really anything that a HR function would normally do internally. We do it externally, mainly because an organisation is lacking capacity or capability around their HR professional needs. So consulting can be anything from developing employment contracts, policies, position descriptions, award and pay audits, through to doing disc profiling, leadership development programs, executive coaching. It could be helping you with an organisational restructure and everything that goes with that. So anything across the range of HR. HR team is a core service for us. So HR team is focused on a small to medium-sized business, normally anything from about 30 to 300. And what we do is we go in and do a health check, we develop a plan, we do an engagement survey. The plan is developed for a year, it's prioritised, and we implement around the needs of the business, which will be different for each organisation. Recruitment and onboarding, mainly around professional and manager and exec roles. And My HR Experts is our online subscription site, which gives you access to a lot of tools and training to do it yourself from a HR perspective. So that's a little about us. Okay, so like I said, there's a lot, and the next slide actually talks about all the changes that have happened, but there have been, as I'm sure everyone's aware, recent updates to the Act that introduce various changes to law, including the right to disconnect, the way casuals are treated, independent contractors and union delegates, specifically the areas that we're going to talk about today. There are some other key changes which I'll mention, but we won't go into a whole lot of detail. But in terms of what we're looking to cover today, it is that right to disconnect. So explore the new provisions surrounding employees' right to disconnect from working outside of hours and how these get implemented into your organisations. And that is where just depending on position, what you do in your business, it will be very different for each person and organisation. Casual employees, so understanding the refined rights of casual workers, so including conversion has changed to permanent employment and what these changes mean for your workforce. Then we will also look at independent contractors versus employees, and that is the new employment definition. So navigating that. And finally, we'll just cover off on union delegates' rights, which have already come in, but there's just an enhancement of those. And we'll mention some of the other key changes. Okay, so hopefully you've probably seen this, but 26th of August is where we're at. So most of those items that I just talked about are sitting in there, that new definition of employee versus employer. The new minimum standards around employee-like workers we will be covering. Additional rights for delegates, for regulated workers we'll be covering. The changes to casual employment and that new right to disconnect. So we're focusing on that area, but you'll see there's already been a whole raft of changes come through over the last 12 months or so, and we still have more upcoming. Okay, so let's move to our first topic. The hot topic, I think, is the new right to disconnect. So on the 12th of February, Federal Parliament they passed the amendment, the Closing Loopholes Number 2 Act for 2024, and that was the final part. There were two really of the Australian government's industrial relations reforms. The Closing Loopholes Bill was split into two. The first one we probably remember maybe was called Secure Jobs, Better Pay. So they've gone through. But amongst other things in this new part is that right to disconnect, the new right to disconnect. So how did this come about? So back in 2022, the Senate Select Committee drew attention to availability creep, where employees were increasingly expected to work outside of hours due to the accessibility provided by smartphones and the shift to remote work following the pandemic. Further, some of you probably heard about the report that was published, the Centre for Future Work published at the Australian Institute in 2022, which revealed that 71%, 7 in 10 workers, reported having performed work out of their schedule. So the right to disconnect was introduced in response to these challenges by giving employees more certainty about their working hours. Okay, so in terms of how it's been implemented, all I would think have been implemented now. There was due for the amendments to the modern awards to be made from Monday when it was effective. So this is an example of what's gone into the Clerks Private Sector Award, which basically is referencing back to the Act, and the Act is what contains the provision. So this is from the Act, so very exciting to see the words. So an employee right to disconnect, so employee may refuse to, and they're using these words consistently, monitor, read or respond to contact or attempted contact from an employer outside of the employee's working hours unless the refusal is unreasonable. And we'll talk more about what that is. And then again, they have basically the same clause again, but they're talking about third parties, so whether or not that would be customers, clients, suppliers, or others. So it's, not just about being in contact with the employer, it's also about those third parties relating to their work. So we've got the dates there, 26th of August, which that's been implemented now, but for small business, it's another year away. And the Fair Work Commission does have new powers to deal with disputes between an employer and employee about these new rights to disconnect, including making orders to stop an employee from refusing contact or to stop an employer from taking certain actions. Okay. Okay, so like we've just said, while the right itself is pretty straightforward, I'm sure you've probably already all experienced the complexity that comes with it, and it cannot be viewed in isolation with other work practices. For example, it must be considered in the context of when an employer can request an employee to work reasonable additional hours, which we have in many contracts, especially in professional and manager and exec, that reasonable additional hours, which is also under the Act, that employees are required to work reasonable overtime. Further, a hybrid working world, as given the increase in flexible working arrangements that many employees enjoy, but then what is considered to be outside of hours in those circumstances, that could be challenging to assess. The impact of the provisions may be less significant for senior managerial and professional employees in light of their seniority, their duties and their remuneration. For employees with on-call or standby allowances, which I think I mentioned again on the next slide, or similar arrangements, the laws are also likely to have little practical impact. However, for other employees, including those in lower paid or junior roles, the right may be a source of disputation in the workplace. and could pose practical issues for employers, for example, seeking to find sick leave relief at short notice. So that's a little bit more about that. Okay, so what is contact outside of working hours? So interestingly, the government and the Greens have stated that the right is not intended to prevent employers contacting employees outside of hours to check shift availability or to deal with emergencies or critical work. However, those exceptions haven't been set out in the legislation as factors for assessing whether a refusal is unreasonable or in the Fair Work Commission in terms of them deciding on a dispute or a stop work order. So as a general rule, when an employee has left the workplace for the day or logged off from their employer's systems, that's outside of working hours. Employees can, and we mentioned this just in the previous slide, can contact an employee on if they're being paid on a standby, on-call or recall with their allowance to notify the employee that required to attend or perform work. If it is in accordance with the usual arrangements for such notification, where there is an emergency roster change. So that's when, when we talk about that, if it is in accordance with the usual arrangements for such notification, we need to really ensure that we have that documented and that expectation isn't a new one that we start. But if that has been a practice that's reasonable, then we just need to look at how that is being applied and how that's documented. Okay, so when is refusal unreasonable? So without limiting the matters that would be taken into account to determine when a refusal is unreasonable, the following have been said, and this is straight out of the Act, the following must be taken into account. The reason for the contact or attempted contact, and importantly, it's always contact and attempted contact in the definitions, how the contact or attempted contact is made and the level of disruption the contact or attempted contact causes the employee, the extent to which the employee is compensated, first point, to remain available to perform work during the period in which the contact or attempted contact is made, hence the previous slide with the paid allowances, or, and I should say not just those allowances too, if we're looking at senior professional manager exec roles, is in that their remuneration compensates them for that, or for working additional hours outside of the employee's ordinary hours of work. You must also consider the nature of the employee's role and the employee's level of responsibility, as well as the employee's personal circumstances, including family or caring responsibilities. And separately from that is it will be unreasonable if the contact attempted contact is required under a law of the Commonwealth or state or territory. It'll be unreasonable to refuse the contact. So in terms of disputes, there is a new dispute resolution process around this. So it applies if the employee is refusing to monitor, read or respond to contact, and there is an employee dispute because of that, and the employer reasonably believes that the refusal is unreasonable, or the employer, I think that's a test, the refusal is unreasonable and the employee believes it isn't. So there's the dispute happening there. So what we need to do is step one is that workplace level discussion. So in the first instance, the parties to the dispute must attempt to resolve the dispute at the workplace level by discussions between the employer and the employee. If that doesn't work, then there's an application to the Fair Work Commission to deal with the dispute. If discussions at the workplace level don't resolve, then that's where it's going to go. So either party or both may make an order under section there, which is orders to stop refusing contact or to stop taking certain actions, and otherwise deal with the dispute in some other way. So there is, they have put power behind it in terms of resolving the dispute. But more importantly, on the next slide, is employees are prohibited from taking adverse action against an employee for exercising the workplace right, so to disconnect. So that's that general protections claim. So it's sitting under that area in terms of adverse action general protections. The penalties are fairly significant. So really employees need to be really cautious about disciplining employees for exercising that right to disconnect. Okay, so as employers, so what I've done with this presentation, we've got each of the sections and I've actually put the actions for employers in as they relate to each section of the changes. So under this section of the new right to disconnect, so what you need to do as employers is you need to prepare for this, what is already effective in the legislation from Monday. So you need to review the existing terms of employment and consider how they may be relied upon in any dispute concerning any contact to an employee outside of hours. Whether or not that's a contract change or a policy or guideline, it depends on your organisation. You need to review the existing employment contract templates and, if necessary, make amendments to clearly define the nature of the role to be performed, hours to be worked, and recognise that the remuneration compensates employees for monitoring, reading, and responding to contact outside of hours. We've all got some, well, most, we probably all have, I would think, some general words about that reasonable hours and doing extra hours to meet the requirements of the job, but we need to get really specific, ideally, on what that looks like. We can try and plead the existing clauses, but I think where it's sitting at, and it's difficult, what I should have said as well, is that there have been no guidelines really released on this. And so what's been said is that maybe 12 months down the track, there'll be some more specifics about it once they've got some cases and disputes coming through. So it's difficult to know the specificity of how to apply these. But, if we are going to make changes to employment contracts, we don't need to repeat what's in the Act, but we do need to be clear about the expectation of that role. So if we're expecting that additional contact, then we probably need to look at amending the clause in our employment contracts. But that probably, may not be the case for more junior employees where this right is within the Act. And so therefore that trumps what's in contract. House recognised reading or something. Consider whether any additional mechanisms are necessary in light of operational requirements. For example, if you are expecting people, especially junior people, lower paid people, to be available, you might need to look at paying some sort of availability allowance or something similar to that. Ensure that managers, importantly, are aware of the new right, including in connection with making employment decisions, for example, performance management, redundancy selection, disciplinary decisions, as the right to disconnect may be relied upon under that general protections claim, adverse action. So they need to be really careful about those decisions and how they're acting in those areas. Following on from that, what I would encourage is an open conversation with employees and the team about their working hours, expectations and operational requirements, just to get some feedback from them and, help in terms of addressing this area. So first of all, we need to look at what the current practice is. So I'm sure we've got policies and contracts about it, but what's actually going on in workplaces? What's the extent of that out-of-hours contact? So thinking about, what's the implications from a health and safety perspective. So the committee would hopefully have some information, note the psychosocial risk that exists, what teams are generally making contact after hours, if it's specifically some areas, who is usually required to respond, what is the contact generally about, do you need to do a survey of your employees or use some other tool to ascertain areas of risk. Review position descriptions and duties as necessary is also important. So all things that, in the last two slides that as employers you need to be looking at in your workplaces. Just a little note on, maybe technology can assist you, maybe it can't, it depends on your workforce, but I thought I would include this. Ask your team if they think it would work. Do you think it would work? But options are around, can emails be easily identifiable as urgent or not urgent, so that everyone knows that they're not expecting a response outside of working hours. Or maybe if there's an urgent, you have a practice of, you send them a text message to say, I've sent you this email, I really need you to look at, rather than just sending a whole raft of emails and no one knows what the priority is and not. Maybe using the delay for sending emails. So we need to consider the delay so it doesn't open again until you're back at your computer or the time that you set. Emails could include a note in the footer reminding the recipient of the email of their right to disconnect, or maybe also, probably what's more practical is including those working days and hours in footers. Protocols for subject lines that help recipients quickly determine whether an immediate response is required. Another idea. You could use computer software that shows a co-worker's recipient status in real time. We use Microsoft, I'm sure everyone else has it, but in Teams you can see that in terms of availability or not, or whether they're on leave, and you could look at your own coding around that. Out of office emails. Do employees need emails on their phone? Do they really? That's a question to think about. I know we have it, but does everyone need to be doing that? Okay, so that's the end of our discussion around the new right to disconnect. I understand it is exceptionally new for all of us, but I'm hoping those tips I gave you are a good place to start thinking about how you can address it for your workplace, but I think importantly having conversations with your people. Okay, next section is around the changes to casual employees. So there's three main areas we're going to talk about. So the casual definition, there is a new pathway, which is what it's called, to full-time or part-time employment for casuals and those employee and employer responsibilities. Okay, so firstly, these changes, like I showed earlier on, they are effective or were effective from the 26th of August. So a new definition of casual employee has been introduced to the Fair Work Act. Under this definition, a person is a casual employee if, when they start employment, the employment relationship, keywords which we'll talk about, no firm advance commitment to ongoing work, taking into account a number of factors that we'll look at, and they're entitled to a casual loading or specific casual pay rate under an award, registered agreement or employment contract. I'm sure maybe you're asking the question, what about casuals employed before the 26th of August 2024? So employees classified as casuals who were with the employer before that date will stay casual unless they move to permanent employment. But for casuals employed from the 26th of August 2024, Monday, the new casual employee definition will apply. So to talk a little bit more about, and there's other rules around that too in situations, so we'll go into some of it, but not all of it. Firm advance commitment is an important part. So whether there is a firm advance commitment needs to be assessed on a number of factors, which I'll go through, which is the real substance, practical reality and true nature of the employment relationship. Are they really casual? And several other factors. The other factors may include, but are not limited to, the employer can offer or not offer work to the employee, and not just can they, but also that's happening in reality, that they do or don't offer. They can or can't. The employee can accept or reject work, and again, that is happening in practicality. It's reasonably likely that there will be future work available of the kind the employer usually performs in the employer's business based on the nature of the business. That's leading more towards the not casual. There are full-time or part-time employees performing the same kind of work in the employer's business as the work the employer usually performs. That is moving towards not casual. The employee has a regular pattern of work, even if it changes over time due to, for example, reasonable absence because of illness, injury or other leave. Again, that's leading more to a not casual arrangement. This isn't a full list and other factors definitely may apply. For this assessment, not all factors need to be satisfied, and a single factor will not determine whether a person can be considered a casual or not. It's very clear, very grey. For example, a regular pattern of work on its own does not indicate that an employee has a firm advance commitment to ongoing work. An employee who has a regular pattern of work may still be a casual employee if there is no firm advance commitment to ongoing work. When assessing whether there is a firm advancement work, you can look at the employment contract or the contract as well as any mutual understanding or expectation between the employer and employee that isn't part of the contract. So we've got the contract, but what else is happening and what other agreements of verbal or emails, whatever else might be going on. The mutual understanding or expectation can be worked out from how the contract is actually performed or what the employer and employee do after entering into the contract. So that was a lot of information. But important when we're looking at that no FAM commitment around the new definition. Okay, this has just come from the Fair Work site, so I thought I would just include it as an example. You can have a read through it. I don't need to read it for you. But important to consider in this case is there's an ability to refuse shifts. There's a weekly roster, but it varies based on different business needs. He's paid a 25% loading. Everyone else are casuals as well. It's a temp business venture, so unsure about ongoing business. So importantly, that meets that definition of that there's no firm advance commitment. And importantly, they are also paid the casual rate, which meets that definition of casual. Okay, so there is new what they're calling employee choice pathway. So basically it's replacing the old casual conversion rights that exist or obligations rights that existed. Again, 26th of August, it's effective from. The new pathway has been introduced for eligible employees to change to full-time or part-time permanent employment if they want to. It replaces the current rules that we talked about. So this has also gone in towards. I had a quick look at the clerk's award, and has gone in. It's sitting at 11.5. It's a new section around offers and request for casual conversion. Again, it's referring back to the National Employment Standard. An employee can only refuse the notice for certain reasons, then narrower than what they used to be. Casuals employed before the 26th of August 2024 and their employers can continue to access additional pathways, the casual conversion pathways, to permanent employment for a further 6 months or 12 months if it's a small business. Employment before 26th of August 2024 won't be counted when assessing eligibility for this new employee choice pathway. So it starts with an employee making a notice. So a casual will be able to provide written notice to their employer to change to permanent employment under the employee choice pathway if they meet a couple of requirements. They've been employed for at least 6 months, 12 months if a small business, and they believe they no longer meet the requirements of the casual employee definition. A casual can't provide notice if they are engaged in a dispute about changing to perm under the choice pathway, or if in the last 6 months their employer refused a previous notice or a dispute was resolved. So 2 parts. One is you're going to receive notice. Second part is you need to respond to it. So before responding, it's an important component that's been written into the Act is that you must consult with the employee. So you need to sit down and have a discussion with them about what they want, why they think that they're not a casual, and discuss how it can happen in terms of what the position or hours or whatever might look like. So this includes discussing certain details of what will change if the employee accepts the notice and the employee is no longer a casual employee. So an obvious one is that casual loading is no longer payable, but they do get entitlements to leave. Annual leave and personal leave paid. This includes, and other things, obviously, other entitlements. So this includes whether the employee would be full-time, part-time, what the hours would be, and when the change would take effect. The employee must respond in writing to the employee within 21 days of the employee giving the notice, either accepting or not accepting the change. So if they're accepting the change, the employer needs to provide a written response and they must include information about the new employment status. For example, they're going to be full-time or part-time, what the new hours of work are, and when the change will take effect. So changes must take effect from the first day of the employee's first full pay period, starting from after the employer gives their response, unless the employee and employer agree on a different date. On the other side, if you're not accepting the change, again, the response needs to be in writing and you need to include the reasons for the decision, which we're going to look at the options around that. Again, a lot of information, and there's actually a whole lot more of information, but hopefully that covers off on some of the key points. You're going to receive notice. It's not about you offering or meeting that requirement to let them know their rights. It's about them providing you with notice that they want to convert based on they think they meet the criteria, and then you need to respond either accepting or not accepting. However, if we look at the reasons for not accepting, the reasons can only be any of the following, which is the employee still meets the definition of a casual employee. There are fair and reasonable operational grounds for not accepting the notification. So just to get that words right, fair and reasonable operational grounds. So such as, but not limited to, the substantial changes would be required to the way work in the employer's business is organised. There would be significant impacts on the operation of the employer's business, or substantial changes to the employee's employment conditions would be necessary to ensure the employee doesn't break rules that apply to the employee, such as an award or a registered agreement. Or accepting the change would mean the employee won't comply with the recruitment or selection process required by law in terms of having to put it out to others. So that's the reasons for not accepting, which are very tight to that you need to stick to if you are going to refuse. Again, I'm just putting this up in terms of an example that the Fair Work have provided. So in looking at this one, the employee choice about casual employment, they started after the 26th of August. She's been there for 9 months, so she meets that 6-month requirement, unless it was a small business, then it's 12 months, but they've said it's not. She's rostered to work every week. She's always been able to, they've always been able to offer her work. There's ongoing work available in the future. They've got part-time employees doing same role. So she's provided written notice. They've had a meeting which talks about what it looks like, and they discuss it, and then it's accepted in writing and the details are confirmed. So that's an example. Okay, so importantly, from an employee perspective, is you can't take certain actions to avoid your obligations around this new entitlement for employees. That includes not reducing or varying an employee's hours of work, changing an employee's pattern of work, or terminating an employee's employment to avoid having to move them from casual to permanent. Casual employees are also protected against adverse action, again, by an employer because they have a workplace right to move from based on that criteria to move to perm employment and to provide the notice, including their right to notify their employer that they believe they no longer meet the definition of a casual. They receive a written response from their employer in relation to their notice, and they participate in dispute about changing to permanent employment. So any of these things is about exercising a workplace right. So if we take adverse action against them, then you've got a general protections claim potentially coming your way. So again, be careful. The dispute resolution framework, like we've said, there's powers that have been given. There's a mandatory framework to resolve the casual conversion disputes, shouldn't say casual conversion, may involve arbitration if not resolved. Best practice is to just get really clear about your processes, how you're going to respond, what your criteria is, and who communicates on these decisions as well. So that is the new right in terms of the pathway for employees to permanent employment, casual employees to permanent employment. So there are definitely some differences there. So again, you need to be looking at your employment contracts around casuals, but also the practicality. It's amazing all too often that we see lots of long-term casuals that are getting even leave entitlement. So in practicality, it might not be in contract, but if they're getting that, understanding also they're definitely casual employees who don't want to move to permanent employment, which is fine, but you need to meet your requirements as the employer. Next section, and I'm just looking at time, so I will get it moving. Independent contractors. So there's a few different changes, which is the definition, of employment, impacts on contractors, sham contracting, it's a bit already happened, unfair terms in contracts, and regulated workers will go over. Okay, the big one that I'm focusing mostly on is there's a new definition of employment. It's been added to the Fair Work Act to help determine the meaning of employee and employer. This is used by some businesses to work out whether a worker is an independent contractor, a contractor, or an employee. To work out if someone is a contractor or an employee, you must consider, and this is again new, it's changed many times over the years, but at the moment this is where it will be now, is you must consider the real substance, the practical reality and true nature of the working relationship. So, and all parts of the working relation between the parties, including contract terms and how the contract is performed in practice. So again, we're down to looking at, yes, there's a contract. What does the contract say? But also practically, if we're treating them like an employee and everyone else, and we'll go through the factors here, then they're an employee, and you need to be very careful about continuing to say they're a contractor, even if they're saying they want to be a contractor. Okay, so applying the new definition may mean that some working relationships are characterised differently. It may also result in different rights and obligations for the people that are affected. The new definition also doesn't affect the meaning of employee and employee and other existing laws, just importantly. It doesn't change the definition around contractor and employee for tax, super and workers' comp. So this new method is known as the whole of relationship test. This test can generally only be used by constitutionally covered businesses, proprietary limited businesses. The whole of relationship test determines if a worker is a contractor or an employee by considering the real substance, like I said, the practical reality of what's going on in terms of the operation of the relationship. So there's several factors. These are just some of them. It's not a complete list. So the amount of control, that's the big one. The amount of control over how work is performed, and there's a whole lot of other information that supports what that means. The financial responsibility and risk. So, for example, if they do something wrong, do they have to go back and fix it up on their own time? Who supplies the tools and equipment? Ability to delegate or subcontract work to someone else. Their hours of work and how they're defined, and regular and all those other things. Expectation of work continuing. So they're the factors that have been provided to help us, but like I say, they're not limited. So they should all be considered. They usually won't be one deciding factor. For example, a worker who has an ABN or issues invoices isn't automatically a contractor. Really important to understand. A worker won't automatically be a contractor or an employee because of the type of work they do. They may perform the same type of work as an employee of a business, but may still be a contractor. So working out if someone is a contractor or an employee can be exceptionally complicated. In some situations, a court may need to determine and does determine the nature of the relationship between the parties. If it's not clear for you in terms of whether you've got people that are contractors or employees, you should definitely get some professional advice on that, because there's huge ramifications for getting it wrong. Other changes that I'm not going over is that new sham contracting defence, which is basically moving from a recklessness approach to the new defence being reasonable belief that the arrangement wasn't lawful. You must now prove that at the time the representation was made, you reasonably believe that the worker was engaged as a contractor. Unfair contract. So Fair Work Commission did have some power. This has been extended. Fair Work Commission for contractors. Contractors can apply to the Commission if they think their services contract contains unfair contract terms. The Commission's able to determine whether a term of service contract is an unfair contract, take into account a range of factors. They can make an order to set aside, amend or vary all or part of the contract. And contractors earning over a contractor high income threshold can't apply for an unfair contract remedy with the Commission. So from 1 July 2024, the contractor high income threshold is $175,000. There's also another avenue to go through the contractor the Independent Contractors Act through court is another way of doing it. And another area is regulated workers. So these changes also took effect from Monday. They're a new category of a contractor that has been created. Regulated workers are contractors doing certain types of work, and they are employee-like workers doing digital labour platform work, contractors in the road transport industry, and contractors performing work in a road transport contractual chain. In road transport, you need to look out for that one. The Commission will be able to set minimum standards for these employee-like workers and regulated road transport contractors. They can do this by either minimum standard orders, they're legally binding, or minimum standard guidelines, which are not legally binding. So that is our independent contractors. So what you need to do is definitely review your independent contractor agreements to make sure they're rock solid, but given the new definitions and the standards, but also importantly is how are they practically being implemented. You may need to implement a framework to assess contractor relationships using that new test, including how contractors are to be used in your business and how you're going to respond when you've got the contractors coming to you with these questions. Okay, finally, and I'm going to go over this very quickly, is union rights, because most of this has already been, has happened earlier in the year. So there have been changes to the right of entry for unions and workplace delegates rights over the last 12 months or so, and they've included the right of entry permits, which came in on the 15th of December 2023. Then also there was another change for the right of entry exemption certificates and permit conditions from 1 July 2024. We had the changes to workplace delegates and their rights effective from the 15th of December 2023. What is coming now is more specifically about workplace delegates of regulated workers, and we just spoke about regulated workers, which have come into play this week. So workplace delegates of regulated workers, it was extended to cover then the new rights covering union powers and workplace delegates' rights to represent the interests of union members who are also regulated workers. So by definition, a regulated business is a business that hires contractors in the road transport industry or a digital platform operator who enters into or facilitates a services contract under which employee-like, again those words, workers perform work. So I won't go further given time, but there's a whole lot of additional rights that have been provided there. This is old, but we've just included, in terms of the new rights around union access, it's just being really clear and understanding what it is and how you're going to respond when the union turns up on your door. Key compliance actions for this area around the union delegates and rights is update your procedures and protocols for union access, ensure compliance with the rights, and proactively engage with unions to avoid disputes and ensure smooth operations. Another change, which I won't cover, but labour hire, that happened earlier, can now apply to receive a protected rate of pay, no less than what they would have received if they were being employed directly by the host employer. Just in terms of a warning, looking forward, the Act is making amendments around criminalising intentional wage underpayments that comes in play next year. Okay, so where to start? This is just a tiny list of where you may want to start. So get your contracts right. So casual and contractors, you need to get them right. So often we see casual contracts that don't have the specific loading in them or have notice periods that are like a permanent employee. So get those contracts right. And the same for your independent contractors. They need to be really solid about the obligations of the contractor. So it's not looking like an employee relationship, but more importantly, next point is what's actually happening in practice for, again, your casuals and contractors, and award and pay audits. So given these increased powers of union delegates, criminalising wage theft, is you need to be really clear about the awards that cover the positions within your organisation and all of the pay requirements, and that's allowances and whatever else. And I'll say it because it just amazes me how often I hear it, is that just because you pay people above the minimum award rate, even if it's significantly, it does not mean they are not award covered. So even if I'm paying someone $80,000 for a job that's $50,000 in the award, I still need to pay overtime, annual leave loading, unless contractually I have entered into some type of agreement, such as an individual flexibility agreement. So be proactive in assessing your workforce. So this is about thinking about your workforce planning. So what is the structure of resourcing that we need? Like, do we need casuals? Do we have the type of work that, or the peaks and troughs that justify the use of casuals? But, part-time, full-timers can be cheaper. So do we, increase our fixed component of the workforce, or do we have those projects and we're going to use independent contractors, and what does that look like? So really looking at what's the practice, but also what's the business need and what are the workforce planning requirements around that. Consult, so engage with the employees about all of these changes that we've just talked about, and listen to them in terms of what they think the challenges, obstacles and ideas are about how to meet requirements or their issues they're having. Leadership training, so much of this is reliant on how your managers deal with all of these issues in terms of, not landing in a general protections adverse action claim around the casual pathway for notification, or a contractor versus an employee, or the union not giving union the access to people that they're now entitled to. So leadership training is really important, and also, just their ability to navigate all the change in work. Leverage technology, we touched on, those out of office messages, email flags, but also just having a really good system for compliance and onboarding of people to make sure you meet your compliance requirements. Policy development, you may need to develop some new policies. There's also been the changes around sex discrimination and harassment that you've now got a new responsibility around as well. So just looking at all the policies that you have in place, not to overkill it, but you just want to make sure you meet the requirements. Regular audits of employment contracts, policies, practice, pay rates, to make sure that regularly everything is working as it should be. Open dialogue with your employees, so we want to create that trust with our employees and our workers and contractors and everyone else about workload, what's working, what's not working, but that trust so that they will come to us with issues. Document processes, document. If it's not in writing, then it's very difficult to prove. So make sure that you have a good document trail no matter what you're doing. In terms of how Harrison's can help, this is just, I suppose, some of the ways that we could help around that changes to casual conversion, casual contracts, templates, responding to employees to exercise what is now their rights, the right of entry and delegates, the triage process in terms of access, what that looks like, independent contractor agreements and advice around that area, the right to disconnect, so whether or not your contracts need to be reviewed or position descriptions, the communication to employees, a checklist of things to look at. An award and pay audit, so looking at what your award classifications, award coverages, award classifications or enterprise agreements, and all the entitlements that sit under those. Are you complying with those or not? Review policies for the changes to the Act, and a leadership development program and coaching we also offer. So thank you so much for listening and attending. Really appreciate it. I hope you've enjoyed and got something out of it. Please, if you're not connected with me, connect on LinkedIn and feel free to reach out and ask for any of the resources that I've mentioned or any questions that I haven't answered, and happy to answer those. But thank you. I'm Claire Harrison from Harrison's, and bye for now.